नमस्कार दोस्तों, रैंकर्स क्यू में आपका स्वागत है। आज इस वीडियो में मैं आपके लिए लीगल डिक्टेशन लेके आई हूँ। सो गेट रेडी फॉर द डिक्टेशन। The instant case is factually very similar to the case of Uday within brackets Supra, wherein the following facts were found to exist. The prosecutrix was 19 years of age and had adequate intelligence and maturity to understand the significance and morality associated with the act she was consenting to. She was conscious to the fact that her marriage may not take place owing to various considerations including the caste factor. It was difficult to impute to the accused knowledge of the fact that the prosecutrix had consented as a consequence of a misconception of fact that had arisen from his promise to marry her. There was no evidence to prove conclusively that the appellant had never intended to marry the prosecutrix. To conclude, the prosecutrix had left her home voluntarily of her own free will to get married to the appellant. She was 19 years of age at the relevant time and was hence capable of understanding the complications and issues surrounding her marriage to the appellant. According to the version of events provided by her, the prosecutrix had called the appellant on a number given to her by him to ask him why he had not met her at the place that had been pre-decided by them, and also waited for him for a long time, and when he finally arrived, she went with him to the Karna lake where they indulged in sexual intercourse. She did not raise any objection at this stage and made no complaints to anyone. Therefore, she also went to Kurukshetra with the appellant where she lived with his relatives. Here, to the prosecutrix voluntarily became intimate with the appellant. She then for some reason went to live in the hostel at Kurukshetra University illegally, and once again came into contact with the appellant at the Birla Mandir. Thereafter, she even proceeded with the appellant to the old bus stand in Kurukshetra to leave for Ambala so that the two of them could get married in court at Ambala. However, here they were apprehended by the police. If the prosecutrix was fact going to Ambala to marry the appellant as stands fully established from the evidence on record, we fail to understand on what basis the allegation of false promise of marriage has been raised by the prosecutrix. We also fail to comprehend the circumstances in which a charge of deceit / rape can be levelled against the appellant in light of the aforesaid mentioned fact situation. Thank you.